Imagine standing in a court 400 years ago. There are no television cameras, no appeals court, no DNA testing, no forensic science, no Supreme Court waiting to review the case, only a rope. On a chilly morning in 1608, one of the leaders of England's struggling Jamestown settlement was marched before fellow colonists and executed. His name was Captain George Kendall. He had been accused of spying for Spain. Whether he was actually guilty has never been proven. The evidence against him was weak. The proceedings were rushed. There was no meaningful opportunity to challenge the verdict. Once the sentence was carried out, there was no way to undo it. America's first recorded execution had already demonstrated the greatest weakness of capital punishment. If the government makes a mistake, death leaves no room for correction. That execution marked the beginning of more than 4 centuries of state-sanctioned executions in what would eventually become the United States. Thousands of people have since been executed. Some were almost certainly guilty. Others almost certainly were not. Tonight we're examining the history, the cost, the morality, and the future of capital punishment in America, and why one of the nation's oldest punishments remains one of its most controversial. Jamestown was founded in 1607. The settlement nearly failed during its first year. Disease spread rapidly, food was scarce, relations with indigenous people were uncertain. The colony was struggling simply to survive. In that tense environment, suspicion flourished. Captain George Kendall was a respected member of the governing council, but he soon became entangled in political rivalries. He was accused of conspiring with Spain against the English colony. The allegation was incredibly serious. England and Spain were geopolitical rivals, and espionage during wartime was viewed as treason. Today, such a charge would trigger years of investigation, classified intelligence reviews, defense attorneys, appeals, and multiple layers of judicial oversight. In 1608, there was nothing like that. Colonial leadership acted quickly. Kendall was convicted and shot by a firing squad. Whether he was actually a spy remains unknown to this day. Historians still debate the evidence because there's so little reliable documentation that survived. It is entirely possible that political rivalry played as much of a role as genuine proof. And once he died, the truth no longer mattered. If Captain Kendall's case were tried today, almost every part of the process would be challenged. Modern criminal justice recognizes numerous constitutional protections. A defendant has the right to a legal counsel, the right to confront witnesses, the right to examine evidence, the right against self-incrimination, the right to appeal, the right to seek new trials when new evidence emerges. Many death penalty cases today continue through the course for decades because the justice system recognizes one uncomfortable truth. People make mistakes. Judges make mistakes. Police make mistakes. Witnesses misremember events. Confessions can be false. Evidence can be mishandled. DNA testing has exonerated hundreds of people who had previously been convicted of serious crimes, including individuals who had been sentenced to death. Some were released only days before scheduled executions. Captain Kendall never had that opportunity. His execution was final. His case became history. From that first execution in Jamestown, capital punishment became woven into American law. Colonial governments inherited English legal traditions. In the 1600s and 1700s, dozens of crimes could result in execution, not just murder. People could be sentenced to death for horse theft, counterfeiting, arson, piracy, burglary, robbery, slave revolts, certain forms of treason, and in some colonies, even repeated property crimes. Public executions became community spectacles. Thousands gathered to watch. Authorities believed public punishment would discourage future crime. Instead, execution often became public entertainment. Children attended. Vendors sold food. Crowds cheered or jeered as prisoners met their fate. Over time, however, society began asking difficult questions. Was execution truly preventing crime? Were innocent people dying? Was justice being served or simply vengeance? Those questions have shaped American history for more than 2 centuries. So for much of American history, murder was far from the only crime that could earn a death sentence. The legal systems inherited from England treated a surprisingly wide range of offences as capital crimes. In the colonial period and well into the 19th century, execution could be imposed for offences that today would almost certainly result in imprisonment rather than death. The philosophy was simple. Fear of death was expected to discourage crime. But over time, Americans began questioning whether that assumption was actually true. Jurors became increasingly reluctant to convict defendants when they knew a guilty verdict automatically meant execution. Governors issued more pardons. Legislatures gradually narrowed the list of crimes eligible for capital punishment, and by the early 20th century, the death penalty had become increasingly focused on intentional homicide, although several significant exceptions remained. History records numerous executions that would almost certainly never occur under today's constitutional standards. One of the best-known examples involves people convicted of rape where no victim was killed. For decades, several states permitted execution for rape alone. One of the most significant cases was that of Coker versus Georgia in 1977. The Supreme Court ruled that executing someone for the rape of an adult woman where the victim survived violated the Eighth Amendment's prohibition against cruel and unusual punishment. The court concluded that death was a disproportionate punishment for a crime that, while horrific, did not involve the taking of a life. 30 years later, the court expanded that reasoning. In Kennedy versus Louisiana in 2008, the Supreme Court ruled that states could not impose the death penalty for the rape of a child when the victim did not die. The court acknowledged the devastating harm caused by child sexual assault, but held that capital punishment should generally be reserved for crimes resulting in death or crimes against the state such as treason. Those two decisions dramatically reshaped death penalty law in America. Many executions carried out before those rulings would now be unconstitutional. Many people assume that execution for crimes other than murder disappeared generations ago. In reality, they continued much later than most Americans realize. The last person executed in the United States for a crime that did not involve murder was Louisiana inmate James Coburn, executed in 1964 for aggravated rape. That was only a little over 60 years ago. For historical perspective, many Americans alive today were already born when that execution occurred. It serves as a reminder that dramatic changes in criminal justice often happen within a single lifetime. The legal landscape we consider normal today is, historically speaking, relatively recent. So can someone still receive the death penalty for a non-murder crime? Today the answer is both yes and no, depending on the crime. For ordinary criminal offences committed against individuals, the Supreme Court has made clear that capital punishment is generally unconstitutional unless a victim has been killed. However, several federal statutes still authorize the death penalty for certain crimes against the nation rather than against an individual. These include treason, espionage involving especially grave national security consequences, certain acts of terrorism resulting in death, some military offences prosecuted under the Uniform Code of Military Justice during wartime. In addition, Congress has authorized capital punishment for a handful of exceptionally rare federal crimes involving national security or large-scale criminal enterprises. Whether those statutes would survive constitutional challenge in every circumstance remains an open legal question because many have never been tested before the Supreme Court. As a practical matter, modern American executions overwhelmingly involve intentional murders with aggravating circumstances. The debate over capital punishment has changed dramatically. Today, the central question is no longer which crimes deserve death. Instead, Americans increasingly ask whether the government should retain the power to execute anyone at all. That debate extends far beyond morality. It also involves economics. Death penalty cases cost enormous sums of taxpayers' money. The legal appeals often continue for decades, and when researchers compare those costs with life imprisonment, the numbers surprise many people. So what is the financial cost of the death penalty? One of the biggest surprises in the death penalty debate has nothing to do with morality, it has to do with money. Many people assume that executing someone costs taxpayers less than housing that individual in prison for the rest of their life. In reality, the opposite is generally true. Death penalty cases are significantly more expensive than cases resulting in life imprisonment without parole. Why? Because the justice system deliberately builds in additional safeguards when a person's life is at stake. Capital cases require specially qualified defense attorneys, additional investigators, expert witnesses, more extensive jury selection, separate sentencing proceedings, mandatory appeals, state post-conviction reviews, and often years or decades of federal court litigation. By the time a death sentence is ultimately carried out or overturned, the total cost can exceed several $1 million per case. Numerous state studies have found that seeking the death penalty often costs substantially more than sentencing a defendant to life without the possibility of parole. For states already struggling with overcrowded prisons and limited budgets, this creates a difficult policy question. Would public safety be better served by replacing death sentences with permanent life imprisonment and redirecting those savings towards crime prevention, policing, victim services, or mental health treatment? Reasonable people disagree, but the financial debate has become impossible to ignore. Another major source of controversy is who receives the death penalty. Research over several decades has consistently shown that race can influence capital punishment outcomes. Defendants convicted of killing white victims have historically been most likely to receive death sentences than defendants whose victims were black. People of color, particularly black defendants, have also been disproportionately represented on death row relative to their share of the population. These disparities do not prove bias in every individual case, but they have fueled ongoing debate about whether the death penalty is applied consistently and fairly. Adding to those concerns is the issue of wrongful convictions. Since the 1970s, more than 190 people sentenced to death in the United States have later been exonerated and released after evidence showed that they had been wrongfully convicted. Some cases were overturned because of DNA evidence. Others involved false confessions, mistaken witness testimony, prosecutorial misconduct, or newly discovered evidence. Each exoneration raises an unsettling question: how many innocent people may never have been discovered before their execution? The discussion about capital punishment also intersects with the broader cost of incarceration. Hundreds of thousands of people in the United States are incarcerated for drug-related offenses, although only a portion are serving sentences solely for simple possession. Many others were convicted of trafficking, distribution, manufacturing, or offenses linked to organized criminal activity or repeat offending. Maintaining such a large prison population costs taxpayers tens of billions of dollars each year. Supporters of sentencing reform argue that expanding treatment programs, diversion courts, and rehabilitation for lower-level nonviolent offenders could reduce prison populations and lower long-term costs, while allowing correctional resources to focus on individuals who pose the greatest threat to public safety. Critics respond that accountability remains essential and that sentencing should continue to reflect the seriousness of each offense. Like the death penalty itself, this debate often centers on how society balances punishment, deterrence, rehabilitation, and public safety. The way executions are carried out has changed dramatically over 4 centuries. America began with public hangings and firing squads. In the late 19th century, many states adopted the electric chair, believing it would be a more humane alternative. Later came the gas chamber, then lethal injection, introduced during the 1970s and 1980s as a medicalized, less visibly violent method of execution. In recent years, however, lethal injection has become increasingly controversial. Many pharmaceutical manufacturers, particularly those based in Europe, refuse to allow their medicines to be used in executions. Some companies place strict contractual controls on distribution. Others stop producing certain drugs altogether. As supplies dwindled, states experimented with new drug combinations, leading to several highly publicized executions that took far longer than expected, or raised questions about unnecessary suffering. Because of these difficulties, several states have revived older methods. Some permit firing squads. Others retain the electric chair as an option. Most recently, a small number of states have authorized execution by nitrogen hypoxia, in which oxygen is displaced with nitrogen gas. Supporters argue that it can produce unconsciousness quickly, while critics question whether sufficient evidence exists to conclude that it is a humane method. The search for a humane execution continues. a reminder that even after centuries, society still struggles with how or whether the state should take human life. So in conclusion, more than 400 years have passed since Captain George Kendall was executed at Jamestown. His case reminds us that every death sentence rests on a simple assumption: that the government has reached the correct conclusion. Supporters of capital punishment argue that some crimes are so horrific that no lesser punishment can adequately reflect their severity. Opponents argue that no justice system, however careful, is infallible, and that an irreversible punishment carries an irreversible risk. The debate is unlikely to disappear anytime soon. It touches questions of justice, mercy, deterrent, public safety, race, cost, and the proper limits of government power. Whether America ultimately expands, restricts, or eventually abolishes capital punishment, the discussion will continue to challenge lawmakers, judges, victims' families, defendants, and citizens alike. Because once a sentence of death is carried out, there is no appeal beyond history. If you liked this video, please click subscribe, and thank you so much for watching.